Hi, I'm Michael Buscema.
I'm Olivia Jackson.
And we're from Aptum Legal, and today we're talking about some of the challenges clients find in litigation and how their lawyers can help them navigate that path.
You might want to be vindicated in your view and go all the way to trial and see it through. I can only think of a few examples or times where that is actually the best approach to take.
And it leads into a lot of the early conversations we have with clients here at Aptum, where a client will approach us with a particular issue and they have that particular outcome in mind, which they picture is going to court and winning in the next few months. And we say, all right, let's take a step back. What are your objectives and what are the issues, so that we can come back to them with various, what we call resolution pathways to say, well, you can take this path or this path or this path. This is what that journey is going to look like. And this is how they each get you to a outcome, which is actually more aligned to what you want, rather than waiting a year, multiple years before you get your day in court.
And I think it feeds into a good point, which is that knowing your objectives is so important. Once you know your objective, we can help you find the pathway there. But without knowing where you want to end up in litigation, it's very easy to just be scrambling madly to, I guess, feel some sort of a win when that might not be the best path to your objective.
And I think that a resolution pathway is useful because it describes the journey to take to get somewhere, not necessarily a lawyer saying, I think you can win and I think you've got a good legal argument. The journey of getting to an outcome is one that involves a lot of contribution from a client. You're not going to get your day in court or another outcome simply by going into litigation thinking you can offload everything onto your lawyer and the rest is then their problem, because it actually involves more engagement and time and effort emotionally and just mentally to deal with the dispute at hand.
And sometimes it shifts throughout. So you might start off giving your all to trying to get an alternative resolution and end up having to commence proceedings when you could have resolved it beforehand, but sometimes it's worth giving that a go, even if it's not successful.
I found it interesting when you have not only a client, but there's other parties involved as well. Got to matter where the client is a large company, they've got their board, they've got their chief technicians, and just within the own entity, they've got their own drivers. And we had a tax dispute where they felt quite victimised by what happened and thought that they had a good position. And then counsel was engaged and counsel was adamant that they had a great position. And everything to that point before we were engaged was, well, let's fight this. And then you get to the point where you map out for them, all right, well, what are the steps in fighting that? And you map out what the ATO's internal dispute functions are and their objection process, and then the tribunal or the court process, how long each of those take. If they disagree, what does the appeal process look like? And very quickly we found that the technical people for the client were like, yes, we want to continue making this point. But the board was like, you know what? Maybe we want a quicker outcome. So the pathways changed and we pivoted to exploring some alternative dispute resolution mechanism, which has generated an outcome that the client can live with. And it's not what they wanted originally, but it's probably prevented them being in dispute for the next 5 years. So it raises the point around, if you don't revisit what that pathway and what your objectives are, because they can change over time, there's a lot of sunk cost in not doing that regularly, particularly if you've got people who've been involved from the outset or you've got multiple viewpoints. It's very handy for the lawyer to sort of just harmonise those views and say, well, if you took that path, took this path, you can often lead to a different decision to one you thought had been agreed on earlier.
A common distraction that I see in litigation is that people zero in on responding to everything and responding to every allegation in a letter. Say, for example, the other side writes a letter and sets out a history that's just incorrect. In our response, it might not be the time to properly respond to every aspect of that, and it might not be helpful too, because the more you go into the weeds with the back and forth in litigation, the further often you get away from a resolution and more into just a tit for tat rather than trying to make some more significant strides.
Yeah, because the whole idea of having a resolution pathway is that you know where you want to end up. And as part of that pathway, you need to understand, well, in order to end up there, we need to resolve these critical issues. And if you know that and you have that framework, you know when you are met with issues that aren't critical. That doesn't mean you can always ignore them, but you're right, you can get bogged down where either your own lawyer, but particularly the other side's lawyers, are raising a bunch of issues and you feel, going back to the vindication point, oh, that's not true, I want to fight that. Every moment and every amount of cost you spend fighting the non-critical points is time and money you're wasting or not spending on trying to put forward what you say your position is on those critical issues. So I agree that sidetracks most people in litigation.
You know, we have to play a critical role in letting them see what are the drivers that are going to, the critical issues that are going to drive the dispute and keeping it focused on that so we can get that outcome as soon as possible.
I also think that people who aren't fully informed as to what the full process looks like might be particularly gung-ho at the start and be like, yes, this is what I'm going to do. If they're not fully informed of what that process and everything required to get there, they could reach a point where they realise, actually, I'm not too sure I want to put this much effort into this anymore, or I don't want to put this much money into this anymore, or actually I realise I'm going to have to front up to the court and give evidence. I'm not sure I want to do that. And if you're not informed and you then reach that point, your whole strategy gets blown out of the water and you completely need to readjust, and that takes up even more time and costs, and you sort of need to start that process again.
I think a sign of a good relationship with the client is that they can ask you any questions about any aspect of the process that they maybe don't understand and they need to understand more, because the last thing I would want is for someone to feel like they're being taken on a journey that they're not fully in control of. So I think something that we do well is we revisit objectives quite often and we try and keep anchored to what our overarching goals are throughout the dispute.
I think it goes back to what a client expects from their lawyer and what they should look for in a lawyer. Because I'm sure in your experience you found that most clients just trust that their lawyer knows what the law is. And they're not asking you about the law. They just want you to tell them what they need to do sometimes, which is always a bit of an issue because a lawyer, in my view, shouldn't be telling you what to do. They should be informing you with knowledge as to what you should do next. The only way you can do that is for the client to know, well, based on what I want, what are the things we need to figure out and resolve here, which requires them to understand their objectives, it requires them to understand the key issues and the strengths and weaknesses in their own position, which they can trust you on whether or not that's a strong or a weak claim, but arming them with that information for them to make their own decisions.
I see the role of a lawyer as essentially like a translator. You're translating the law for the client, and I feel like you often have to put on your law hat and then your client hat because these shouldn't be so vastly different, but sometimes they are. And trying to work out what is the important information that we need. And it might be easy for us to describe that in some sort of legalese way and think that that will translate to the client, but it doesn't. I think the sign of a good lawyer is being able to bring the client into what they need to know to get the best outcome. And for example, to find the most relevant information. It's not just information that relates to this rule that who knows what that means except lawyers. So that I feel like it's really a communication role.
Because we need to put ourselves in the shoes of the clients to understand their objectives, but we can never fully be in the client's shoes. All we can do is understanding what their interests are with respect to those things that we're not there for. We don't know their other commercial drivers or what's going on at home or a bunch of other things. All we can tell them is having an awareness of those issues, giving the legal advice on the matter, whether or not, what risks at least they pose in each of those regards so that they can do the weighing up themselves. And I think it's important that there's a relationship with the client, acknowledges that you're there to help them weigh that up and make their own decisions.
It's funny because a lot of the times there does need to be some sort of commercial decision from them, and we unfortunately can't make we can't make the decision for you. And I feel like a million times I've heard, what would you do if you were in my shoes, which is always a tricky question. If we can equip them with the information that is relevant to them, not just, okay, these are the pros and cons. Some people really like, this is a percentage chance of your success. Some people like, this is a visual map that shows the different avenues you could go down. And I think that's also very client dependent.